Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. And, of course, the StreamYard link is there for anybody that wants to join the panel. We've got Iman with us tonight. How you doing tonight, sister?
All is well, brother, for right now. I just got a little hiccup, but I'm good.
Good deal, good deal. All right, well, let's get into it. Tonight we're going to talk about that safe harbor again, but we're going to talk about it as part of diplomatic foreign service. And this goes to that thing about you feed a man a fish, you feed him for a day. You give him a fish, you feed him for a lifetime. Or you teach him to fish, you feed him for a lifetime. And the principle of that is the education. And like I said before, most of us walk out of high school with a high school diploma. So it has to do with being able to be diplomatic upon foreign people, foreign entities, and knowing those different languages that they speak. So we're going to talk about that safe harbor again, and we're going to go back to the very first one that we looked at last night. Oops, let me first start with this, I guess. We talked about the courts of probate having no jurisdiction to appoint an administrator of an estate of a living person. That's Scott versus McNeil. Okay. And this is in relation to the Health and Human Services Estate Recovery Program. We mentioned that. Office of Inspector General and their mission is to protect the integrity of the Department of Health and Human Services programs, as well as the health and welfare of beneficiaries served by them. Public service is a public trust. So tonight, we're talking about the immutable promise to seek counsel in God, the plenipotentiary powers, force majeure, property damage for loss incurred upon fines, fees, penalties, etc., related to all actions of plaintiffs in all administrative court cases, family court, including but not limited to known adoption, so as to settle original inherent estates. Strict liability for personal injury assessed at $10 million. Amicus curiae, friend of the court, in the name of the United States and for the account of the United States, for possible subrogation claims of any debts owed their account. Intent of full acquittance and discharge to make all parties whole, and for the person making the same, so that no person shall be held liable in any court pursuant to this directive. Non est factum unconscionable agreements enumeration at birth does not reflect knowing intent. So let's take a look at it. Got to get rid of this and start sharing again. So when we look at the safe harbor regulations, see if I can blow this so everybody can read it real good. And this is from the Office of Inspector General of Health and Human Services, of whom we just read that integrity, protect the integrity of the Department of Health and Human Service and the beneficiaries whom they serve. The safe harbor regulations describe various payment and business practices that, although they potentially implicate the federal anti-kickback statute, are not treated as offenses under the statute. Safe harbor regulations in their entirety can be found here. And we took a peek at that last night as well. We'll take another peek. Links to Federal Register notices containing preambles to the safe harbor regulations appear below. And then all of these. So all you got to do is look up Health and Human Services, Office of Inspector General, Safe Harbor Regulations. This should pop up. And they're telling you it's about anti-kickbacks. Telling you that they can go ahead and get kickbacks, but they're not treated as offenses under the statute. What are they getting the kickbacks for? That's that material document that mom gave them as an informant that has no investment intent or statement of financial intent, but yet it's invested in. United States citizen, that's a business. It's got to be an investment. It's got to be capitalized, collateralized. So let's take a look. These are what I was talking about, part of the use of the matrix. The matrix are the contract terms and conditions that they place throughout these codes. That's all these are. Warranties. As used in Section 1128B of the Act, remuneration does not include any payment or exchange of anything of value under a warranty provided by the manufacturer or supplier of one or more items and services to the buyer, such as the healthcare provider or beneficiary, of the items and services, as long as the buyer complies with all of the following standards in paragraph G1 and 2 of this section, and the manufacturer or supplier complies with all the following standards in paragraphs G3 through 6 of this section. So the buyer has two basic points of obligation. The buyer, unless buyer is a federal health care program beneficiary, must fully and accurately report any price reduction of an item or service, including a free item or service, that was obtained as a part of a warranty in the applicable cost reporting mechanism or claim for payment filed with the department or a state agency. The buyer must provide, upon request by the secretary or a state agency, information provided by the manufacturer or supplier as specified in paragraph G3 of this section. Now this is G3, and it says the manufacturer or supplier must comply with either of the following standards. That language right there is very slick. That's the disposition of a liability to another party. Unbeknownst to the manufacturer or supplier must fully and accurately report any price reduction of an item or service that the buyer obtained as part of the warranty on the invoice or statement submitted to the buyer and inform the buyer of its obligations under paragraph G1 and 2 of this section. Did anyone get that notice of obligation? Information.
Where is the notice of obligation?
Well, why are you required to give any kind of information? You would have to be part of that association to first be required, or first to then be required.
Oh, I thought you were asking a question.
No, that's just plain. You're not subject to this unless you're part of that association. Part of that association, as we use the terms here, is buyer and seller. So you have to understand what you're doing in all these contracts and everything. They're actually contract terms and conditions required to implement the statutes or executive orders - commercial items, commercial services. And like I said, everybody's being considered to volunteer their personal services to manage the estate for which the state is administrating through the Social Security Administration, and they're the ones that authorize you to do so. That's a public office. You're performing the functions of public office, trade, or business. You've established yourself as a person representing that, as a being the representative of the person in commerce. Nowhere else. And that goes to the estate. That's the probated estate. So let's take a look at another document I found, because this is interesting. This is a recent case from Iowa, in the Supreme Court of Iowa. Number 21-192, Johnson County, number LACV 082557, Jerry L. White, plaintiff appellant. Michael Harkrider, City of Iowa City, Chris Wisman, and Johnson County, defendants, appellees. Interlocutory appeal from the Iowa District Court in and for Johnson County, Honorable District Court Judge Chad Kepros, presiding. Conditional amicus brief of the Iowa Association for Justice. Iowa Association for Justice by Chair Amicus Brief Committee. Certificate of service, all that, The Municipal Tort Claims Act does not obviate the need to determine and declare that Article 1, Sections 1 and 8 are self-executing. This is your ability to contract. The Act's grace is no substitute for the Constitution's demands. In other words, the statutory acts, if they fail, then you fall to the Constitution, but you have to go through a certain administrative process first. Then it says the Act's liability shifting provisions undermine deterrence. And this is what I was just talking about. They're dispositioning the liabilities. They call it the Act's liability shifting provisions undermine deterrence. In other words, there's no real deterrent to it if they're not going to prosecute them. Know what I mean? The construct, this is an interesting one, the construct of sovereign immunity is overwhelmed by the plain text of the Bill of Rights. See, the sovereign immunity is within their statutory codes and executive orders, whereas the Constitution's Bill of Rights in its plain text, like the plain writing in government documentation, is clear. Then he gives a conclusion. So let's look into it. It's got a bunch of these cases and stuff here. And this is interesting here because, like I said, it's an Iowa case. So he's got these Iowa codes here. He's even got State of Iowa versus Wright, State versus Brown, 2021, 2019. So these are recent cases. These are all Iowa cases here. City of Sioux City versus Jacome, 2015. Gacky versus Pork Extra, LLC, Iowa, 2004. Godfrey versus State, 2017. Kriebel versus Henkel, 1911. McClurg versus Brenton, 1904. So you got a couple long-standing ones as well as a bunch of modern ones. You got some United States Supreme Courts. And like I said, on constitutional provision, Article 1, Section 8. That's your arts and sciences and your right, protected exclusive rights to your writings and discoveries. That's why I say coin your words or purse your lips. And we're going to take a look at these codes here. Then he's got Iowa court rules, other state cases, Identity and interest of amicus curiae. As stated in the Iowa Association for Justice, hereinafter IAJ, motion for leave to file amicus curiae brief filed contemporaneously with this brief, incorporated herein by reference. The IAJ is an organization comprised of over 700 attorneys primarily practicing on behalf of injured persons. Whether an injury occurs at work, on Iowa's roadways, on a snowy sidewalk, a dilapidated bike trail, a softball field, a school, in jail, at a mental health facility, or in this case, at an innocent person's private home, on her private property, by policemen abusing their power and their tools and the color of their authority. IAJ is there to seek justice and ensure wrongs are righted. For over a decade, from 2010 through 2021, IAJ member and former association president Roxanne Conlon and her team worked tirelessly to ensure that where Iowa's Tort Claims Act failed, the Iowa Constitution succeeded. That's what I was talking about earlier. The administrative procedure, go through the Tort Claim Act first, and if it fails, you've got the Constitution to fall upon. Through multiple appeals, hearings, depositions, that's those dispositions, just a different phrase for the same thing, trials and remands, the Godfrey case established that even when the legislator neglects to grace us all with a legislative remedy for state constitution violations, nonetheless, the Iowa Bill of Rights is sufficiently self-executing that the judiciary has the power to infer a constitutional damages remedy. See Godfrey versus State, Iowa 2017. This makes sense. Our constitutional rights can never depend upon the mere action or inaction of a single branch of government. This is why they have the separation of powers, and this is why they are interlaced. Now comes part two of the Godfrey saga. Whereas the state was claiming the Constitution was powerless in Godfrey, now here the municipal actors are claiming the same fake powerlessness of the Constitution for themselves. And like the judiciary rejected the state's policy-based arguments in Godfrey and inferred an independent constitutional tort when a state actor violated Godfrey's rights, so too should this court also infer that same level of protection for Mrs. White, whose rights were violated by municipal actors. So what they're saying is it doesn't matter what your statutes or executive orders are under your contracts of your mayoral form of government with your municipal bonds and all this and that, it doesn't matter. You still operate under the same public service as a public trust, under the same judiciary, executive, legislative intents. Each state has their own administration. The protection of the Constitution should be obvious. The Bill of Rights does not depend upon whether the tortfeasor works for the city or the state. Very powerful language there. It does not depend upon whether the tortfeasor works for the city or the state. So what gives them the excuse to excuse themselves? That's a violation of the Constitution itself. Our rights are God-given and inalienable. They are not subject to the grace or restraints of others. IAJ is committed to ensuring that the Bill of Rights in Iowa remains the best in the nation, which was the intent of our framers. IAJ is committed to ensuring that civil constitutional law does not become a race to the bottom in Iowa, immunizing possibly thousands or tens of thousands of municipal actors for the constitutional harms is contrary to the plain language of the Bill of Rights. is inconsistent with Iowa case law and federal precedent, and it would undermine both the deterrent and make whole theories of the self-execution doctrine. Our liberties we prize and our rights we will maintain is not just a catchphrase on the flag or a cliche we were all forced to memorize in third grade social studies class. That motto is our sacred creed. It is the command of our forefathers. It is what attorneys and the Iowa Supreme Court justices took an oath to protect, defend, and uphold. No law, nor any absence thereof, can ever permute or destroy what is guaranteed to us by our Creator. The Iowa Supreme Court should reverse the District Court, confirm that the Iowa Constitution restrains state actors and municipal actors too. This case should be remanded for trial. I don't know what you guys think, but that seems to me the clear defining of what the constitutional powers actually are, and that is superseding any tort claim feasors, no matter whether you work for the government or not. That's why it has that Bill of Rights. What do you think, sister?
I'm sorry, brother. Forgive me. I was what do you call it? Multitasking.
Oh, okay.
Yeah.
Well, that says I caught you off guard then. That's fine. We'll just move on to the next thing here.
What was that question, though? I'll write it down.
I was just asking what you thought about everything so far with this document. And I'm going to go ahead and drop it in chat.
Okay, sure. Thank you.
That way everybody's got it. Okay, there we go. And so the next one I wanted to go over was those Iowa codes he mentioned. So let's take a peek at them real quick. Oops. This is Iowa code. It says tort liability of governmental subdivisions. And this is something I've mentioned before, that residential zone, that foreign trade zone, zoning improvement plan, that's based on political subdivisions, school subdivisions, tax subdivisions. And it says, as used in this chapter, the following terms shall have the following meanings. Governing body means the council of a city, county board of supervisors, board of township trustees, local school board, and other boards and commissions exercising quasi-legislative, quasi-executive, and quasi-judicial power over territory comprising a municipality. In other words, they're exercising as if they have legislative power, as if they have executive power, as if they have judicial power or authority, and they don't. That's as if. Quasi means as if. Get that through your thick skulls first. Municipality means city, county, township, school district, a Chapter 28E entity as provided in Section 670.4, subsection 1, paragraph B, in any other unit of local government. Any other. So it's got to be in a class of units of local government. Remember that resident determination in Iowa for income tax purposes. And then, of course, the resident in the federal code is no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. And of course, that would mean you would be a unit of local government. And like I said, it's not United States, it's United States. You're a contract postal unit. Officer includes but is not limited to the members of the governing body. Tort means every civil wrong which results in wrongful death or injury to person or injury to property or injury to personal or property rights, and includes but is not restricted to action based upon negligence, error, or omission, nuisance, breach of duty, whether statutory or other duty, or denial or impairment of any right under any constitutional provision, statute, or rule or law. See, they really don't have any authority or power to be doing what they're doing when the entire record is in error. Anything, Iman? Okay.
Okay, now what did you say about the entire record being in error?
Yeah, if it's the United States is a United States business, means a United States citizen, and that citizen has a standard to be born in the United States, or the birth has to be registered in the United States, and there's no such registry, it's an
Correct. There isn't.
impossibility. It's an error.
It
The
is an
entire
error.
record is.
It is. It is an error.
Again, in my opinion and my discernment. So the next one I got is 670.4, claims exempted. Isn't that the one we just spoke about? 670.4, provided in 670.4, subsection 1, paragraph P. So let's see if we can find paragraph P. Any claim against a Chapter 28E entity or an officer or employee of the entity in any way arising out of or related to the acts or omissions, operations, or acceptance of waste by the entity at the request of federal state agencies or any political subdivision of this state in response to a disaster emergency declared by the governor pursuant to section 29C.6 subsection 1 in any way related to infectious or contagious disease as defined unless the Department of Natural Resources determines the entity materially deviated from the entity's direct responsibilities and duties under the special waste authorization issued by the department. Huh. Anybody been given that notice? So let's take a look at the very first one, because this is the interesting part. The liability imposed by section 670.2 shall have no application to any claim enumerated in this section. Any claim by an employee of the municipality which is covered by the Iowa Workers' Compensation Law. Any claim in connection with the assessment of collection of taxes. Any claim based upon an act or omission of an officer or employee of the municipality exercising due care in the execution of a statute, ordinance, or regulation, whether the statute, ordinance, or regulation is valid. See, it doesn't even have to be valid, folks. Or based upon the exercise or performance or the failure to exercise or perform a discretionary function or duty on the part of the municipality or an officer or employee of the municipality, whether or not the discretion is abused. So whether or not the discretion is abused and whether or not the damn thing's valid or not doesn't make a damn bit of difference. There's some kind of exemption. How the fuck is that? Huh? Any claim against a municipality as to which the municipality is immune from liability by the provisions of any other statute, or where the action based upon such claim has been barred or abated by operation of statute or rule of civil procedure. See, I don't know that the Constitution, when it comes to the President Trump and these other people, and I'm not voting for or against Trump. I'm just saying my piece and opinion here, because to me it just seems like a big play. Because if it was really true, I would think that they would go to the constitutional element that doesn't allow for statutory. What did they call it earlier? What was it? What did he call it here? Liability shifting provisions that undermine deterrence. Liability shifting provisions that undermine deterrence. What is there if any claims against a municipality as to which the municipality is immune from liability by the provisions of any other statute, or where the action based upon such claim has been barred or abated by operation of statute or rule of civil procedure? Where are they getting this shit? Okay, I know of nothing. They would have to bring forth that claim. They don't. They just it's there. No, that's a statutory provision, which is not enforceable. That means you have to go to the Constitution. Do you understand that, folks? Any claim for punitive damages, any claim for damages caused by a municipality's failure to discover a latent defect in the course of an inspection. I'm not making a claim for damages in the tort claim. I'm making a claim in equity as a reversion to a merger of the estate with a private trust. So I may manage my estate privately and not through some kind of false administrative probate estate. And that has absolutely no authority to do so. Any claim based upon or arising out of a claim of negligent design or specification, negligent adoption of design or specification, or negligent construction or reconstruction of a highway, secondary road, or street as defined in section. See, we're talking about certain things. A claim under this chapter shall not be allowed for failure to upgrade, improve, or alter any aspect of an existing highway, secondary road. Why? See, these kind of claims don't apply to us. Any claim based upon or arising out of a claim of negligent design or specification, negligent adoption of design or specification, any claim based upon an act or omission by an officer or employee of the municipality or municipality's governing body in the granting, suspension, or revocation of a license or permit where the damage was caused by the person to whom the license or permit was issued, unless the act of the officer or employee constitutes actual malice or criminal offense. And I got to remind you, folks, while you're sitting there with that license or that state ID in your pocket, remember it's got the state's name on it first, and then you're playing the part as the officer or agent, and then giving an address as that agent in trust. You're playing the part of the trustee, as the principal has you under some kind of contract, and that is evidenced by the very card you're holding.
So, Brother Keith, does that mean that the address that's being used, is that an implication that it's a business
Yeah,
principal,
primary
a
place of
principal,
business. Yeah, principal place
right?
of
Primary
business
place of business,
as a
correct?
contract postal unit, part of the United States. Any claim based upon an act or omission of an officer or employee of the municipality, whether by issuance of permit, inspection, investigation, or otherwise, and whether the statute, ordinance, or regulation is valid, if the damage was caused by a third party, event, or property not under the supervision or control of the municipality, unless the act or omission of the officer or employee constitutes actual malice or criminal offense. Again, and this is why we give them notice, because once you give them notice, they're not supposed to act inappropriately by misappropriating funds based on a fact that you've already clarified and rebutted. Hey, we have to fix something here. It goes again to the integrity of the Department of Health and Human Services, which is their record, and accordingly the welfare of the beneficiary. A claim based upon or arising out of an act or omission of a municipality in connection with an emergency response, including but not limited to acts or omission in connection with emergency response communication services. Emergency response communication services is the dispatch. For the purposes of this paragraph, municipality includes a nonprofit corporation. See that? That delivers such emergency response services on behalf of a city, county, township, or benefited fire district pursuant to a written contract. Pursuant to a written contract. The city, county, township, or benefited fire district shall file the written contract and any amendment, modification, or notice of termination of the contract in an electronic format with the Secretary of State within 30 days of the effective date of the contract, amendment, modification, or termination in a manner specified by the Secretary of State. A claim relating to a swimming pool or spa, okay? A claim based on an act or omission by a county or city pursuant to 717(2)A or 717(B) relating to either of the following: neglected livestock, maintaining or disposing of neglected livestock. Any claim for injuries or damages based upon or arising out of an act or omission of an officer or employee of the municipality or municipality's governing body in arising out of a recreational activity, and arising out of a recreational activity occurring on public property where the claimed injuries or damages resulted from the normal and expected risks inherent in the recreational activity. So let's take a look at this. Joint exercise in relation to that contract. This is where they transfer their jurisdictional powers through the joint exercise of governmental powers. So when the local police are called by the local postal service through dispatch, there's a governing contract. So they have joint exercise of powers. And then the agreement with other agencies. Obligations not excused. Status of interstate agreement. Approval of statutory officer. Contract with other agencies. Powers are additional to others. No limitation on contract. Oh, here we go. Transit policy. See, all the way down to the municipality, that's that freedom of transit is guaranteed throughout the entire territory of the Union. The first article of the Constitution of the Universal Postal Union. So let's take a look at that next Iowa code that we're looking at. Officers and employees' personal liability. All officers and employees of municipalities are not personally liable for claims which are exempted under Section 670.4, except claims for punitive damages and actions permitted under Section 8520. An officer or employee of a municipality is not liable for punitive damages as a result of acts in the performance of a duty unless actual malice or willful, wanton, reckless misconduct is proven. So again, the administrative process that says, okay, well, I've given you notice that what you're doing is causing loss, damage, and injury. Here's how. And this is an injunction, an estoppel. You're no longer supposed to be doing that. You're treating me wrong. You're not treating me as a proper American. You're treating me as a United States citizen, as a business. There are distinctly different interests involved, and you're causing harm to me. Once you give them that notice and they still move forward and press on in that commercial interest in those commercial venues of Article 1 corporate courts, as if though you're a United States business, when in fact you know you're not and they have no evidence that you are, again, that's an impossibility. There's no birth registry in the United States proving that such a business exists. There's implications. There's records on an individual, and any individual's name and number identify the record. It does not identify me. Quit misidentifying me. And then, of course, the next one, when it relates to those punitive damages, is the money judgments. Money damages, non-waiver of rights. This chapter shall not be construed to be a waiver of sovereign immunity. So here we are wrapping right back around. Like I told you folks, the safe harbor is much like an immunity. So let's work with the immunity. This chapter shall not be construed to be a waiver of sovereign immunity for a claim for money damages under the Constitution of the state of Iowa. So that tells us they recognize sovereign immunity under the Constitution of the state of Iowa. That's where the immunity comes. But again, you have to be just and righteous about your actions. If you're out there maliciously doing it because you know you're not going to be prosecuted, then that's what we're talking about, is the undermining of the deterrence, the shifting liabilities. Why are we calling each other with liabilities when we have immunity on both sides, as long as we conduct ourselves in good faith? So again, I want to swing back around then. Welcome back, Iman. I want to swing back around then to that diploma. Because when it comes to the diploma, it's a matter of being able to go out on the foreign lands and teach others what you've come to know. And that's the importance of the education. So again, you feed a man for a day if you give him a fish. You feed him for a lifetime if you teach him to fish. But the inherent principle is the aspect that you go out and share that message to others so that they too can feed themselves for life and share that message. Just sharing the technique of fishing isn't it doesn't encompass the whole thing. That's like the faith part of it. But faith without works is dead. The true work of it is being able to share that talent in teaching so that others take that talent and teach. Not just go around giving each other fishes or feeding themselves for a lifetime. And with that, we come to the end of tonight's stream. Again, as it relates to that safe harbor and using that as an aspect in your own sense. But again, using that equity aspect, he who wants equity must first come with equity. He who seeks equity must first come with clean hands. Make sure what you're teaching is true and pure, that you have firsthand experience with it so that others can accept it and use it. You got anything on the way out, sister? All right. Well, I guess she's off multitasking for the moment. So with that, folks, we are out. And you know me, I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. Bye now.